now, and we will share the recording with all attendees following this session, probably usually by the end of the week, but tomorrow's off, so I think probably next week. And then I have a few disclosure slides to share, so I'll do that really quick. Okay. All right, so this activity is jointly provided by USET and Cardia Services. Cardia Services is approved as a provider of nursing continued professional development by Montana Nurses Association and accredited approval with distinction by the American Nurses Credentialing Centers Commission on Accreditation. This activity has been planned and implemented in accordance with the accreditation requirements and policies of the California Medical Association through joint providership of Cardia and the United South and Eastern Tribes. Cardia is accredited by CMA to provide continuing medical education for physicians. So today, upon completion of this activity, you have the option of requesting continuing education units. So since this is a live web-based training, there will be awarding a maximum of 1.5 AMA PRA category credits. Physicians should claim credit commensurate with the extent of their participation in this activity. There are no relevant financial relationships with ineligible companies for those involved with the ability to control the content of this activity. And lastly, in order to get your continuing education units, I'm going to share a link in the chat at the beginning and at the end of the session. You need to complete the webinar with us today. And then you also have to fill out an evaluation, which is what that link will take you to, along with the CE request. But everything will direct you through that link. And your certificate will be sent to you via email. If you have any questions about this continuing education activity, please contact Tristan Stitt at tstitt@cardiaservices.org, or you can send me an email and I can connect you that way too. And let's see, anything else? No, I'll share the link in the chat, but I am going to hand this over to Jennifer Downs and Heather McLean.
Okay, thanks, Emily. Good afternoon, everyone. I'm Jen Downs, and I am Washoe, and I am the behavioral health consultant for the Nashville area for IHS. I'm just going to be opening us up, and then at the end, kind of closing us out and handing things back to Emily. Heather McLean is actually going to be our speaker today. And I'm going to share her bio with you in just a minute, but just to give you kind of a preview, Heather's going to go through her PowerPoint, really walking through 42 CFR and all of the details of that. And we're anticipating that will take the first hour, and then we've reserved that last 30 minutes for a question and answer time for you all, really to ask anything you want related to what she just presented, or ask what you want. I've found in my role that a lot of people have questions about whether or not 42 CFR applies to them, and if so, how it applies to them. So we wanted to give you all time to ask those kinds of questions, but you can really ask anything. And then we also, Heather has some sample forms, and we went ahead and pasted those into the end of the PowerPoint. So if we don't have a ton of questions and you all kind of want to walk through those forms and the details of it, then we have that time to do that as well. But anyway, just wanted to kind of let you know what's coming, and I'll go ahead and introduce Heather. So Heather McLean is the Senior Official for Privacy of the Indian Health Service. She has worked for IHS for 11 years. For the last 6 years, Ms. McLean has been the Senior Official for Privacy, and before that, she was the IHS Great Plains Area Health Information Management Consultant and Area Privacy Coordinator. Heather's also worked for the state government as a medical records administrator and for an Alaska Native owned nonprofit healthcare organization. She earned an Associate of Arts degree as a paralegal in paralegal studies, a Bachelor of Arts in Healthcare Management, and a dual Master of Business Administration degrees in healthcare management and in human resources. Ms. McLean is both Native Hawaiian and Alaska Native, in addition to being Kanaka Maoli. She is enrolled with the Chulista Corporation and is a descendant of the Meskulik Corporation and Cook Inlet Region Incorporated, 3 of 12 land-based Alaska Native regional corporations created by the Alaska Native Claims Settlement Act of 1971. And if I mispronounced any of that, Heather, you can correct me, but we can go ahead and open it up, Heather, if you want to take over now.
Perfect. That was actually a pretty good pronunciation. It's pretty handy. So before I start, I want to make sure that everybody can see my screen that says confidentiality.
We can see it.
Is that a yes? Perfect. Okay, great. So we're going to cover the substance use confidentiality regulations, which are 42 CFR Part 2. There are some places where these regulations perhaps conflict with the HIPAA regulation and with the Privacy Act regulation. So we'll cover those, how they conflict and which regulation takes precedent in those situations. So it can start to get confusing. Just a little notice, I cut my back teeth in substance use. So I am intimately familiar with these regulations. I know them backwards and forwards by citation. So often what makes sense to me, maybe I might say it in a way that confuses you. If I do that, don't be scared to stop me. I'm more than happy to provide clarification where needed.
Heather?
So again, we're going to cover, go ahead.
Oh, just really quick. If you press full screen mode, we have, like, right now we see it kind of in the layout of your slides, which is fine. But you can it would be bigger on people's screens if you in the bottom corner kind of like.
Yeah, I usually don't do that because I flip around between them. Yeah, so if it's, let me know if it's big enough that you can see it.
It's fine for me. I have like 2 monitors, but I just wanted to make you aware.
All right. So we're going to cover again the confidentiality requirements for dealing with substance use diagnosis or disorder records. So we're going to again cover the Part 2 regulations with emphasis clearly on the patient's right to privacy, as well as the role of HIPAA in the Privacy Act where it does apply. So the most confusing thing that gets the most questions is when it comes to applicability of the Part 2 regulations. So when we look at applicability, these regulations apply to 42 CFR Part 2 bound providers who are Part 2 covered, providers and who are federally assisted. And they also apply to records that are in the possession of other lawful holders. And we're going to cover this definition quickly of a lawful holder. So a lawful holder is anybody who is in possession of Part 2 patient identifying information, who is an individual or an entity who receives the information as a result of a Part 2 compliant release of information, or as obviously as a result of one of the 9 exceptions to the non-disclosure rule. For the most part, we are generally lawful holders as receiving information from a Part 2 program. And in the cases where we're a lawful holder, whether we ourselves are a Part 2 program or not, we're required to protect the record under Part 2. So Part 2 often will wiggle its way right into any medical provider's program. So we're going to cover the 3 definitions of a Part 2 program. The first is an individual or an entity that's not a general medical facility that holds itself out as providing and does provide substance use diagnosis, treatment, or referral for treatment. So this would be like a freestanding facility, like a YRTC. The second definition is when you have an identified unit within a general medical facility that holds itself out as providing and does provide diagnosis, treatment, or referral for treatment. So you see this section further if the provisions of services are identified as a primary function, that lends itself to the third definition, which can be medical personnel or any other staff in a general medical care facility whose primary function is the provision of substance use diagnosis, treatment, or referral for treatment, and they're identified as such. So there are several examples, and we'll cover those as we go through. The number one example of this is you could have a full freestanding clinic that's just a health clinic and one staff member who is a drug or alcohol counselor, and they're licensed and working as a drug or alcohol counselor. That person by themselves can be a Part 2 program. So the regulation for 42 CFR Part 2 does not define what holds itself out means. However, SAMHSA has established that the definition is any activity that would lead one to reasonably conclude that the individual or entity provides substance use disorder treatment or referral. It includes, but is not limited to, an authorization by a state or federal government. So you're licensed, certified, or registered to provide that service, and you do. If you advertise that you provide that service, or if there are notices out in the community that you provide that service, or there's statements relative to such service. That statement relative to such service can oftentimes be the driver that moves one provider into a Part 2 provider status. So to make that make sense, let's say you have a patient come in to a general medical facility, they tell the provider they're having a substance use issue. The provider can make a referral to treatment, and that is not a Part 2 service. That's just a general medical service. Now the provider's been doing it for several months. Now people in the community know that they can go to that facility and talk to that doctor to get a referral for treatment. That would then move that provider into being identified as providing that service in the community. That can move that provider into being a Part 2 provider. So a Part 2 provider status can change literally daily, just depending on what's out there in the community, whether that is their primary function for that day. And that really comes into play when we look at MAP providers. So we'll cover that further. And then, of course, any provider that provides consultation activities relative to those services. So what does federally assisted mean? This is different. Under the HIPAA regulations, you're federally assisted when you have an IRS, 501. Under Part 2, you're considered to be federally assisted if you receive federal funds in any form, and they don't have to be federal funds being used specifically for alcohol or drug services. If you're authorized, licensed, certified, registered by the government, you're assisted by the IRS for tax exempt status, you have DEA registration to dispense controlled substances to treat a substance use disorder. If you're authorized to provide methadone treatment, if you receive Medicare, Medicaid monies, grant monies from the federal government, those all make you federally assisted. So almost every Part 2 provider in the United States is federally assisted in one way or another. So under the Part 2 regulations, who is a patient? Under Part 2, the key word here is applied for. So under Part 2, if an individual calls a facility to make an appointment for a substance use assessment, the moment they make that appointment, they are considered to be a Part 2 covered patient. So applicability is upon application and not once they've received care. So it has to be upon application. So it's any individual who has applied for and been given a diagnosis or treatment for alcohol or drug abuse at a federally assisted program, and includes any person who, after arrest on a criminal charge, is identified as an alcohol or drug abuser in order to determine that individual's eligibility to participate, say, in a criminal justice system program for substance use. Under the Part 2 regulations, patients are required to receive a written summary of their confidentiality provisions and a notice that federal law and regulations protect the confidentiality of these types of records. This is not the same as a HIPAA notice of privacy practice. This is in addition to a HIPAA notice of privacy practice. So in almost all cases, if you're a Part 2 provider, you are also a HIPAA covered entity. So as a HIPAA covered entity, you provide a notice of privacy practice. As a Part 2 provider, you're required to provide a Part 2 notice. And I have a sample of what that Part 2 notice should look like at the end of these slides. So under Part 2, patient identifying information, it can be the patient's name, address, their social, their fingerprints, their pictures, or any other information by which the identity of a patient can be determined with reasonable accuracy and speed, either directly or by reference to other publicly available information. Written and unrecorded information like a patient's verbal statement would also be patient identifying information. The most important part of the Part 2 regulations is this patient identifying information. Definition, it will come into play all across the 42 CFR Part 2 regulation. So knowing this definition is incredibly important. Under the Part 2 regulations, patients have an absolute right to access their record. That doesn't mean that we hand them their record and they can open it and review it and do all that. That means that a patient has the right to have an appointment with their provider, sit down and have the provider go through their records with them. Patients have that right. If a patient requests a copy of those records, then they have to complete a release of information. But a patient does have an ultimate right to access and view. This will come into play for personal health record, if you have a personal health record, and how that access has to be provided. So the Part 2 regulations are so simple to comply with because there's a general rule under Part 2 that says, nope, you cannot make disclosures of Part 2 information unless you meet one of the 9 exceptions to this non-disclosure rule. So knowing those 9 exceptions can be incredibly important. So those 9 exceptions, the first would be no patient identifying information, internal communications, proper consent, a qualified service organization agreement, crime on program premises or against program personnel anywhere, research and audit, court order, medical emergency, and reporting suspected child abuse or neglect. And we're going to cover each of those. So the no patient identifying information, again, that's where that definition of patient identifying information comes into play. If we're not making reference to a patient as being a substance use patient, then there are items that we can use to make disclosures that might otherwise be required of us that don't necessarily meet a Part 2 exception. So that means when, let's just say we have a patient who falls down at the facility and it looks like they have a broken leg. That broken leg might not meet the medical emergency definition under Part 2, but that doesn't stop us from seeking medical care for the patient. So rather than like calling 911 and saying, this is Heather at ABC drug treatment, and one of my drug treatment patients, fell down and broke their leg, and so I need an ambulance. We wouldn't do that. We could instead say, hey, my name is Heather, and here's my address, and we have an individual that fell down, appears to have a broken leg. As long as we're not identifying them or ourselves as a Part 2 provider, we can make that kind of call. So no patient identifying information has gone out the door. And then next is internal communications. This is one place that we see that an improper disclosure can happen and does very often happen. A lot of people assume, like, if I work at organization A, that means I have a right to access everything. And that is not true. Your access to any information must, be on a need to know basis. And just because you work there doesn't mean that you know or that you have a need to know. So under internal communications, program staff can share information about with another staff person about that patient when it's necessary to provide a treatment-related service. Keep in mind here, the key word is treatment-related service. So let's just say a patient informs his counselor that he has liver disease. The counselor can inform their supervisor, the nurse and the social worker, but there'd be no reason for the receptionist or the janitor to know that they also have liver disease. On the flip side to that, if you have a patient that's suicidal and they let their counselor know, that counselor can inform the supervisor, the social worker, the nurse, the janitor, the reception, anyone necessary in order to monitor that patient. So it's that need to know is a true need to know. Just because you work at organization A doesn't mean everybody in organization A needs to know. And then, of course, with the release of information, there are some caveats to ROI for part 2 in the designation that is now permitted under part 2. And we're going to actually cover this more in depth at the end, but just know there is part of this proper format for ROI. If you're IHS or if you have a contract or compact with IHS, if your contract or compact says that you follow the Privacy Act, then this is also going to apply to you. So pay attention to that. Under part 2, you need the name of the program that's making the disclosure, the name of the program or individual that's going to receive records, the patient's name, the specific purpose for the disclosure, specific information to be disclosed, a statement that the patient can revoke in any time, except to the extent that the program has already acted in reliance on the ROI, the date, event, or condition of expiration, the date of the signature of the patient, and the date on which the consent is signed. And a general medical release form is not sufficient to make a disclosure under Part 2. So these recent statutory changes, this to whom section, under both HIPAA and now 42 CFR Part 2, we can use a general designation in the to whom section of our release of information. And that means that you can say my past, present, or future treating providers, and it would be permitted. However, if your IHS or if your contract says that you comply with the Privacy Act, the Privacy Act specifically prohibits that. They call that a blanket authorization or a blanket consent. So the Privacy Act says that if we have a blanket consent to disclose a subject individual's records to unspecified individuals, i.e. a general designation, it will not be honored. So we have ways, a workaround for that at IHS. We pretty much have a workaround for every bit of this. So we'll cover those workarounds in the sample forms. I just wanted you to be aware of that. So in that to whom, a patient can provide a general disclosure to an entity that does not have a treatment relationship, like as in through health information exchange. That can be kind of tricky depending on how you're gathering information about a patient and where you're storing that information. So to make that make sense, if you are a one entity like the YRTC is not an integrated care facility. They can absolutely use an electronic health record, and they can cover, you know, anybody that has access to the electronic record. Obviously, if you work at that facility, you know that all of your patients are Part 2 patients. That is not the same if you work in an integrated care setting. In an integrated care setting, the expectation is that you'll have a separate paper record, or if you're going to include an individual's information in your EHR, you must have a release of information to do that. So that is a use that is not permitted under the general rule that prohibits disclosure, but one of those 9 exceptions is release of information. So if you have a release of information, you can use that information in your electronic health record. So when it comes to an HIE, if you already have Part 2 information in your electronic health record without the patient's authorization, and you join in with an HIE, then you cannot share that Part 2 information. That also puts you at risk of information blocking using an HIE because we can't share it. we don't have the right to do that. So in order for a Part 2 patient to participate in HIE in an integrated care setting, we need a release of information to include their record in our electronic health record. Then we need an additional release of information to include their record in an HIE environment. So it's not just a one and it covers all. It has to be two separate ROI, one for our internal use in the EHR, one for making it available in HIE. So when you participate in HIE, that's also, that's the treatment side of the house, but this also applies to a personal health record. So if a patient wants to sign up for personal health record to view their own information, they also must sign a release of information to do that. That's a disclosure. They're not with a provider, so it doesn't count as an access request under Part 2. Excuse me. So the amount in kind, if you're familiar with an IHF 810, and we do have one at the end, we'll show you this. We have a box that says my entire record. The patient can click that box and their expectation is that everything in their record would be disclosed. That is not sufficient for Part 2. So under Part 2, they actually have to name the document that they want to be disclosed. Excuse me, i.e. my assessment, my diagnosis, my referral, my progress notes, my discharge summary, whatever the case may be. They should name those documents specifically. They can't just say my treatment record. That is not sufficient. Excuse me. So Part 2 requires that the information be properly described and explicitly described. And then, of course, they can include things like my diagnostic information, medications, my lab tests, allergies, substance use history summary. So they actually are just really getting into the weeds that we wouldn't normally see in a medical environment. So in addition to meeting the requirements of Part 2, those 9 required elements, all of these elements, in addition to that, the HIPAA regulation adds further elements that we also must comply with. So your release of information has to be written in plain language, signed and dated, state what, if any, conditions are placed on the individual in exchange for signing the ROI, whether or not we're going to charge them for copies of records, and that they can actually receive a copy of that authorization. We don't generally run into circumstance where we place any condition on a patient for signing a release of information unless that patient is referred by the criminal justice system. If they're mandated into care by the criminal justice system, meaning probation, parole, drug court, it could be child protective services. If they're mandated, CJS will come into play, and we're going to cover that as well. So under Part 2, it was never before until these changes in 2020 required for us to provide an accounting of disclosure. Under HIPAA, we're used to accounting for all of our disclosures since 2003. For IHS, we've been accounting for disclosures since 1974. So we account for all of our disclosures no matter what. Part 2 now also has an accounting of disclosure requirement. So we track our disclosures, and if we make a disclosure and a patient requests a copy, an accounting, then we're required to provide it to that patient. And we're required to provide it within 30 days. For this piece, there is talk that that's going to be changed to 15 days under the HIPAA regulation. They did post a notice of proposal for rulemaking, but they have yet to finalize that rule. So just know that we expect this 30 days to change to 15 days. And now this is the next tricky thing. Under Part 2, patients are permitted to revoke their release of information. If they revoke their ROI verbally, we are required as Part 2 providers to accept that verbal revocation. So a patient can say, oh, I want to revoke my consent to ABC treatment, and we are required to accept that. The HIPAA regulation says that they have to do that in writing. So Part 2 is never required that be in writing, and that means we must accept a verbal revocation. One of the changes that we're expecting with the new Part 2 regulations that will come out, we're hoping any day now, will be that we in fact will be putting it on our ROI that written revocation is required. However, SAMHSA and OCR will still if we receive a verbal revocation, we will still be required to accept it, but we'll have to have the in writing language on our ROI. That was our last read that we had. Hopefully they'll clarify a little better when they do post a final rule. So that may be changing. Either we will still be able to take verbal, or we'll have to do it in writing. If a patient revokes their consent in writing, there are specific things that we're required to do. We're required to actually write a progress note and log that revocation in the progress note of your chart. And we're required to make a notation on the ROI itself and then scan it into the patient's chart. Obviously, we're moving away from paper at IHS, so we'll be scanning that into a patient chart. And what that means, and let me see if I can do this. The last time I did this, I couldn't do it. That means that if this is my ROI, I'm going to use a red pen and I'm going to mark all the way across my ROI. And then on the bottom, anywhere in the bottom, I'm going to write in there that the ROI was revoked and what day it was revoked. So I do that at the bottom because if you flip through a paper chart, that bottom is normally clear. You'll be able to see very easily that this ROI was revoked. That might be a little different if we're scanning the record and maybe we missed the bottom part of the ROI. So just making sure that it's somewhere that's visible to a staff member that's looking will be incredibly helpful. So here we go with these criminal justice system referrals. As for the revocability, under Part 2, criminal justice system referral, those releases of information are made to be initially irrevocable, meaning the patient cannot revoke their consent until there has been a formal and effective change in their criminal justice system status. So that means that if a patient comes to us as a referral from criminal justice, we shouldn't even accept that referral without a criminal justice system consent. Because if the patient leaves against treatment advice or fails to show up to their appointment and they revoke that consent, we would not be able to advise the criminal justice system that they never showed up. This comes into play a lot when we have patients that are perhaps referred through a furlough program with, the criminal justice system system. They get out on probation in order to go to treatment and then they elope. So then we can't tell them anything. Probation parole doesn't know that they didn't come to us and they're not even looking for that person. So we require that they sign an ROI before they even make an appointment with us. Once there's been a formal and effective change in their status, then they can change and revoke that ROI. So what does that mean? Let's say we do have a patient that's been furloughed, mandated into treatment, and then they leave against treatment advice. We can notify probation or parole that they left against treatment advice. Then let's say probation parole notifies us maybe a month later that the patient's been arrested. Arrest is not a formal change. So that formal change won't happen until they actually go to court and the judge remands them back to a criminal justice system facility. So it's that actual remanding by a court that changes that status. The same would apply with a drug court, and the same would apply with Child Protective Services. So under Part 2, there is a rule that 100% prohibits redisclosure of any Part 2 information that we either receive or that we send out. So every release of information that we make, we are required to provide a prohibition on redisclosure statement with it. That statement is written word for word in the regulation. We're required to provide that statement. We can't make any change to it. So if you send a fax or by mail a patient's records, then you would want to include the prohibition on redisclosure statement. If you're on a telephone call and you're making disclosure on that telephone call, you can provide statement number 2, but you must provide it. And if you do provide it, say on a phone call, you want to make sure that you write a note that includes that you provided the prohibition on redisclosure, because if it isn't in writing, it didn't happen. So when we send out by fax or email, secure email, we include the statement. We can prove that that statement was included. When you're on a telephone call, you can't prove it unless you write it down. So it's an important thing to keep in mind. So then SAMHSA in the last iteration of the regulation in 2018, they clarified that it applies only to information that would identify either directly or indirectly a person as having been diagnosed, treated, or referred for a SUD. So if a patient consents to have their information released to a particular individual, the individual receiving the information can't redisclose it to a third party. And this can be kind of wonky. So let's just say you are a general medical provider and the patient signs a release for you to get Part 2 information from their Part 2 provider. Now you have that Part 2 information. You can't just scan it and make it part of your record. That's not permitted because you can't share it. But what you can do is you can summarize what you've received in a note, and that note would not be considered Part 2. So not copy paste, but summarize. The summary itself would not be Part 2 information and could therefore be freely disclosed. If you copy paste, then prohibition on redisclosure applies. So here's another example. If a patient receives SUD services from a Part 2 program and they receive treatment for another condition like a heart murmur, the patient's record would include information unrelated to that SUD, right? So they're at that Part 2 provider, they tell them they have a heart issue, that information is going to be in their record. That provider could disclose that medical information and could redisclose medical information. So the information under SAMHSA's last clarification only applies to SUD information. If you have other information in your record, it applies just like it would under HIPAA and could be disclosed, say, for TPO. So under the regs, we can only disclose that information which is necessary to meet the specific purpose of the disclosure. So if the ROI, say, is for probation parole, and its purpose is to verify presence and progress in treatment, we most certainly would not send an assessment or discharge summary to the probation officer because that doesn't cover presence and progress in treatment. Presence and progress is, yes, they've been to all of their appointments and they're moving along just fine. That's presence and progress. So being very careful to pay attention to that purpose is very important. The same would apply if we make a disclosure pursuant to a court order. That has to be limited to the criminal and non-criminal purpose stated in the court order. And then again, the accounting of disclosure, this is one of the new things for Part 2. When patients request that, they have to do that in writing, and our response has to include the name of the recipient entity, the date that we made that disclosure, and a description of the information that we disclosed. One other way, one of the 9 exceptions to the non-disclosure rule is qualified service organization agreement. So we can enter into a qualified service organization agreement, or QSOA, with a program that does not provide Part 2 services that would allow us to share Part 2 information. So where would we ever come across that? We come across that with lab services. Labs aren't necessarily Part 2 providers, so we can enter into a QSOA with a lab so that we can share a patient's record with that lab without a release of information. We can enter into QSOA with a billing service, say like DataTrack or Personal Group, and provide them the information without a release of information to conduct that billing service for it. We can do that. We see that, say, if you're familiar with the Winnebago Service Unit in the Great Plains area, the Winnebago Service Unit has a DDU attached. Their drug dependency unit can enter into QSOA with the Winnebago Food Services to provide meals to the DDU. So there's multiple ways that we can use QSOA. The number one way that you cannot use it is with another Part 2 program. So one Part 2 program cannot enter into QSOA with another Part 2 program. That's not permitted at all. So qualified service organization in the last iteration of the regulations now can include entities that provide population health management to a Part 2 program. So we could potentially, like with our tribal epicenters, enter into QSOA to provide them Part 2 information for that population health management that they undertake. If a patient commits a crime on our program premises, we can absolutely call the police and tell the police the particulars of the crime, the patient's name, their address, maybe their last known whereabouts. We can do that without release of information. If we're out, say, at Target and a past client starts harassing us or maybe tries to kidnap us or try to fight with us, we can also make a disclosure to police how we know that client. So this is a disclosure permitted on your program premises when there's a crime on your program premises or a crime against your program personnel, and they can be anywhere. So we can report that without any fear of bumping up against the unauthorized disclosure. We can make disclosure for research purposes. However, research under Part 2 is far different than research under, say, HIPAA or the Privacy Act. The research exception used to just say that we could give information to researchers provided that they pledge not to redisclose our patient information except back to us, meaning that if they were going to write a research paper and have it published, that they couldn't have any Part 2 specific information located anywhere in that research purpose. That is now changed, and we'll cover that. And then subpoenas, court orders. A subpoena by itself is not sufficient to compel a disclosure of a Part 2 program. So a subpoena must be accompanied with either a valid court order or a valid release of information signed by the patient. So what is a valid court order? In order for a court order to be deemed valid, there must be a notice to the patient and the program. So oftentimes we have attorneys that go to court, they file a motion to get a court order for a Part 2 patient's records. That motion is our opportunity to be heard. That would be our notice. So they would be required to send us that unsigned motion. That motion would then tell us when the court date is, when we can go be heard, when a patient can go be heard. So there has to be notice to the patient of the program, an opportunity to be heard. They must use a fictitious name. They must be confidential proceedings, and the judge must find good cause. So fictitious name, confidential proceedings don't apply to drug courts. Patients sign that they understand they're not confidential proceedings and that they won't be using fictitious names. So when it comes to drug court, you'll expect to see their real name and an open court most likely. So search and arrest warrants are the same. If the police show up and flash their shiny badge and expect to receive some records because they have a search warrant or they have an arrest warrant, excuse me, that is not sufficient. So you always want to make sure that you have a copy of your federal regs. Excuse me. Explain that you can't cooperate without a valid court order. If you can, seek the assistance of an attorney. You're always welcome to contact a commanding officer, prosecuting attorney, and explain the regulations. But whatever you do, excuse me, you don't want to forcibly resist the police officer's attempt to enter your program. Generally, if you're faced with that situation and they insist on entering because they have a search warrant, if you advise them that they will be going in completely unassisted, 9 times out of 10, they'll choose not to go in, just for whatever reason. So again, we can make disclosure for medical emergency. We can make that disclosure to medical emergency personnel who have a need for the information to treat the condition that poses an immediate threat to the health of an individual that requires immediate medical intervention. We can make that disclosure to EMTs, but not to a family member unless we already have an ROI for that purpose. But what we could do is provide the EMT with the family member's information, and they can call that family member. They're not Part 2 providers, so they can do that. So there's no consent required for that, but there is a requirement to document that information. So the definition in the past, like in that broken leg situation, if somebody broke their leg, I'm not a medical doctor. I can't look at you and know if you cut an artery or something. So how would I know if you were going to die from that broken leg? I would have no way to know that. So now there is this discretion to define a bona fide medical emergency. In the case of someone that breaks their leg, yeah, that could be a bona fide medical emergency because they could have cut an artery in there. So now I can call the, EMTs or whatever. I can tell them about my patient. But there are other situations where maybe we're not sure. Maybe the patient, passed out. Is that a bona fide medical emergency? I don't know. But Part 2 now leaves that to the provider's discretion to make that determination. That's a huge plus. It used to be pretty much like you were on death's door, and then you could make a call. So this is a good change and update to the reg. When we make a disclosure, we are also required to cover in our progress notes of our chart the name of the person who made that disclosure, the name and affiliation of the recipient of the information, the date and time of the disclosure, and the nature of the medical emergency. So that means EMT 1 and 2, if you give information to EMT 1, you need their name and who they're affiliated with, ABC ambulance service or with a facility. Me being from Alaska, we often would make our medical emergency disclosures to the Coast Guard. So I'd have to have, the Coast Guard's rank and name and which unit of the Coast Guard they were with. We would have to document that stuff. We can make disclosures for child abuse or neglect. We are restricted to only disclose the information. Let me rephrase that. If you make a disclosure for suspected child abuse or neglect, I highly recommend that you include absolutely everything you think an investigator is going to need, because we are limited to our initial report of harm. Once we make an initial report of harm, if they come back to us and want more information, we must have a release of information or a valid court order. So we're limited to just that first disclosure. It's very important. If you think they're going to need it, you give it all. And let me go back there. One mention, you'll notice that this does not include elder abuse. Part 2 only applies to suspected child abuse. Now, if we're in an elder abuse situation, keeping in mind, we can go back to that no patient identifying information. If we don't provide that patient identifying information in our reporting, we can absolutely make a disclosure as a mandatory reporter. So again, that patient identifying information is important. It does come into play. We can make disclosure for specific public health purposes. It's not the same as public health that we're used to under HIPAA. They have to be specific, meaning if the FDA calls and says, hey, we need a list of all your patients that are taking buprenorphine, there's an error in labeling. We can absolutely provide that list of patients, but we can't make a disclosure, say to a tribal epicenter just because they're a public health authority and requested it. So knowing the difference, there's a big difference in this kind of public health reporting. Under normal circumstance, we're not the one that make diagnoses of communicable disease. So we wouldn't normally be the ones to make that disease reporting happen. That would come from the medical provider. So the last Part 2, until it was updated, only applied to paper records. They 2.16 used to be called Security for the Written Record, and they had a requirement. You have your records locked in a locked file cabinet in a locked room. Now Part 2 applies to both paper and electronic records. And of course, they have specific provisions for how you close down a program. If you need to close down a program, they have specific rules about how you go about doing that. So the text and the preamble of the Part 2 reg make it very clear that the responsibility of explaining patient rights falls on the treatment program. So programs should be advised to review their consent documents, their prohibition on redisclosure statements, their QSOA categories, their security policies and procedures, and their general contractual documentation. So here's the security piece that I was just talking about. These security features or requirements now actually more closely align with the HIPAA regulation, but not 100%. Like if you have to move to a new EHR, they have a rule for what you have to do with your old EHR, how you have to store it, etc. So we're going to cover those. And currently, this is going to be a huge deal when these new regulations actually hit the public. So right now under Part 2, enforcement falls to the U.S. attorney in the state where a breach occurs. I can tell you that in my almost 7 years in this position, when I call a U.S. attorney to report a breach, they have no idea what I'm talking about. And I have yet, in almost 7 years, successfully reported a Part 2 breach to a U.S. attorney. They always say, oh, well, if a crime happened, you should report that to the police, even though the police don't have enforcement, only the U.S. Attorney's Office does. That is going to change under the new Part 2 regulation. Enforcement will fall to the Office for Civil Rights. So right now under Part 2, like never has any fine been assessed against the Part 2 program. We all know full well how many multi-million-dollar fines the Office for Civil Rights puts out there for HIPAA breaches or failure to follow the HIPAA regulation. So now knowing that enforcement will fall to the Office for Civil Rights, we fully expect to see those same multi-million-dollar fines for Part 2 providers. Kind of unfortunate, but it is what it is. So again, if you have to make a report of a breach, those can be done to the U.S. Attorney. If you're a MAT program, then those breaches can also be reported to SAMHSA. And as yet, I still don't have a number to report these breaches to SAMHSA either. We know how we'll report for OCR, but right now we just don't know about the U.S. Attorney or SAMHSA. SAMHSA did just post this. So if you're not familiar, under the CARES Act, the CARES Act made changes to the underlying statute for the Part 2 regulations. And that statute requires that SAMHSA does a whole new regulation and that they were actually required to have it posted and final in March of 2021. They failed to meet that deadline. So now they have on their website that they're working with OCR and that even though there are new statutes that are in effect, we are required to follow the regulation as they exist today until they've posted their final rule. So all the changes that we're expecting under the CARES Act are not in play right now and won't be until SAMHSA posts the new Part 2 regulation. So those CARES Act changes, consent will still be required for disclosure of our records by Part 2 program. With a general consent, disclosures and redisclosures can be made consistent with HIPAA for TPO. But we've always been able to do this. Under Part 2, TPO is a consent requirement. Under HIPAA, you don't need release of information to share those records. But under Part 2, you must have a consent. So we still need a patient's ROI to bill their record, to make disclosure of it, and to conduct other healthcare operations, no matter what. So the HIPAA fines and penalties will now be Part 2 fines and penalties. You won't be able to use substance use disorder records in civil, criminal, or administrative proceedings without a court order. They will apply the HIPAA breach notification rules. And again, they changed that enforcement authority from the U.S. Attorney to the Office for Civil Rights. I'm sure that they're all, those OCR attorneys are all quickly trying to catch up with Part 2. That's going to be a pretty big list, I think. So under Part 2, how do you know if you're a program? This can be very, very confusing and can change quite a bit. So let's say you're staff in a general medical facility and you have a Part 2 program. Everything that happens in that Part 2 program must be protected, including from the staff in your general medical facility, unless, again, you have that release of information to include that information in your EHR. If you have MAT providers in a general medical facility, just because they're providing medication-assisted treatment doesn't necessarily mean that they're a Part 2 provider, unless the provision of MAT services becomes a primary function. So MAT services are based on a Data 2000 waiver. They can see 100 patients or they can see 300 patients. If they're seeing 100 patients, it's likely a primary function of their job. How many providers can a patient see in a day, and then multiply that by 20 days in a month? You're likely hovering right there around 100. So it's a primary function. If you have a Data 2000 wave provider and they can see 300 patients, but they're only seeing 100, that's not a primary function. Their services are not Part 2 services. So paying attention, if you have MAT providers, maybe you have 2 in your facility. One of them goes on vacation and starts seeing the other provider's patients. That could move them into being a Part 2 program. So you want to pay very close attention to your MAT providers and the provision of their services, making sure that you count how many patients they're seeing in a month so that you're not making them Part 2 providers if you don't want them to be Part 2 providers. So Jennifer, do you want me to stop here and we'll ask questions, or do you just want to hit forms?
Yeah, how about we go through this one specifically and then we'll stop and just open it up for questions. But I love this. I think that's really handy information. Then we could just open it up.
Okay, good. So this is the IHS 810. And you'll notice this is that box entire record that I was talking about. If that box was ever checked for Part 2 records, it's not valid. It can't be used. So we are using, technically, in this release of information, the general designation of who can receive records, but we're also meeting the Privacy Act no blanket consent requirement. So Mashpee Service Unit can share records with past, present, or future treating providers at Mashpee. Now it's not blanket, we're saying at one facility. So if you have a integrated care setting, patients can sign an ROI for TPO to include their information in the electronic record and to use that information for scheduling and coding and billing for services. Under Part 2, remember, you can't submit a claim. That's not one of the 9 exceptions. So you can't bill for service without a release of information. And that is not the same thing as an assignment of benefits. It has to be a full ROI. So this ROI, for the purpose of treatment payment or other healthcare operations, the Mashpee Service Unit can share between its past, present, and future treating providers a patient's diagnosis, treatment, referral for treatment, including their assessment progress notes, their schedule, their discharge summary, etc., and can use that information for scheduling the patient, coding their visits, and billing for their services. We have this box at IHS. I've never understood why we did this, but we included this little handy dandy section. If you want any of this sensitive information, you got to check the box. If you receive a Part 2 ROI for Part 2 records and this box is not checked and you're IHS, then it's not valid. If you're not IHS, it doesn't matter for you guys. It's not your form, it's our form. I've never been a fan of these boxes. And then we change the date of expiration. So this ROI for IHS says that it automatically expires in 1 year unless I use a different date. And we recommend for the health information exchange that it won't expire for 5 years. Remember that one of the 9 required elements of a valid consent form is a date, event, or condition of expiration. So we can say 5 years after my last date of service, they might be 25 now and pass away when they're 85. That ROI would remain valid for an additional 5 years if they're not being seen anymore. So you can put things in here. You can say 30 days after I finish my treatment. You can say most would prefer to use a 5-year so they can do a 2-year and 5-year recidivism survey with the patients. But you can put 10 years after the date of my signature below, 20 years after the date of my signature below. Those are all permitted. So it's not necessary to limit to just 1 year or to limit just 5 years. Whatever you do, when you fill out an ROI, you want to make sure that you explain it to the patient. So you're providing them with the information they need to make a decision, explain what it means. Between MASH-P and MASH-P, we're going to share these records for this purpose in our EHR. We can code and bill for your services, and this ROI won't expire. And if you agree with that, go ahead and sign the date. So patients can do that. You can also have what's called a two-way ROI. And so we could say between MASH-P service unit and Unity. And that means that they would be able to disclose records between each other. You wouldn't have to have two for two facilities. You could have one to make that exchange. You could have the name of the facility on one side, your facility, and you can name 10 other providers on the other side. As long as they're all getting the same information for the same purpose, it's perfectly legal and permitted to do. So ROI are really dependent on how you choose to fill them out and what information you're looking for and what you're really trying to accomplish with that ROI. Criminal justice system ROI, we don't have one currently at IHS. These are a form that we're currently updating or creating. But in the criminal justice system, again, those patients don't have a right to revoke until there's been a change in their criminal justice system status. So it's just like a normal ROI, except, and I'm going to see if I can make this bigger so you can read that language. It's pretty tiny. They say there's this little box. They have to initial it to say, yes, I understand that I cannot revoke until there's been a formal and effective termination or revocation of my release from confinement, probation, parole, or other proceedings under which I was mandated into treatment. So they can't revoke their consent. That's the only difference between a normal consent and a CJS consent. And do you want to pause for questions, Jennifer?
Yeah, that would be great.
Okay.
You can go through more if you all want to, but we did want to just give you a chance to ask if you have specific questions about your program or about anything that Heather covered, because it was a ton of information, we know. So
Yeah.
you can unmute yourself. You can put things in the chat if you would like to, but the floor is open for anybody to ask questions.
Don't be shy. All questions are good questions.
I have a question. Can you hear me?
Mm-hmm.
So I work at IHS in Oklahoma, and we've been doing the ODAZLs. So it's basically a substance use evaluation for levels of care. I'm also from Minnesota, so they're familiar with Rule 25. So when we do that, is my understanding is that would be protected under Part 2, correct? Even though we really don't provide substance abuse treatment.
No.
I mean, it isn't?
No. So it's just like an SBIRT. We can do an SBIRT all day, every day. And that
Okay.
SBIRT by itself does not necessarily mean that it's a Part 2 activity. In order for it to be a Part 2 record, it has to stem from a Part 2 program.
Okay. So
Does that make sense?
Yeah, because when I'm from Minnesota, ours was always considered, and even in a big hospital system, it was still protected under CFR 42. So I just assumed they were protected because we're looking at the ASAM criteria and looking at placement for them.
Mm-hmm.
Okay. There's no diagnosis on it or anything like that.
Yeah.
Okay.
Now,
thanks.
if people in the community are like, well, I know that I can come here and I can get a referral, now you might be a Part 2 program. So you really want to pay attention to how you're perceived in your community and what you advertise as your services.
Well, we did advertise to the local tribe with their, they had a tour grant. And so we said that we would do their ODAZLs if we needed to, or so I think we did kind of advertise ourselves out a little bit. So
that might change things. So the question there, or the process you would want to follow there is to have a meeting with your OGC and find out if your OGC, here's the activities we provide. This is what we told the community we do. Are we a Part 2 program?
Okay, the OGC it's called. Okay.
Yeah, your attorney.
Oh, okay. I'm new to I'm new to IHS too, so and Oklahoma, so I know the CFR 42 and everything, but it's a little different now where I'm at. So. Perfect.
Yeah.
Thank you.
Mm-hmm.
Heather, I see that Sunny Stone is raising her hand. Sunny, did you have a question?
Oh,
I sure do. So I'm here in Idaho. We have kind of a unique situation. So our tribal health entity, we do the behavioral health, which includes SUD and mental health treatment, and as well as some clinical treatment and things like that. And one of our clinical providers is our MAT provider. And one of the things that we noticed is it's really difficult to provide MAT services through our clinical provider when we can't, communicate between effectively between our SUD treatment folks and the MAT provider. So
that makes me so sad. So that's really, you don't have to be in that situation.
This brings me to my question. So we wanted to bring on our SUD folks into the EHR. We are jointly accredited and share an EHR with our local service unit. So we're 638, and our local service unit is direct federal service. And so the service unit controls the EHR, which we utilize for all of our services except for SUD. And so when requested to gain access to the EHR for our SUD folks so that we can communicate effectively and all of that, we were told absolutely not.
So let me make that make sense. That's not really a Part 2 issue. That stems from a federal information system providing access to somebody who is outside that federal system.
We already have access. So as a tribal health entity, we already have access to the EHR. Our tribal health clinical providers
need a release. Yeah.
Yeah, they have not even allowed us that option. They said absolutely not. We cannot be in their EHR.
Oh my God! Ask them to set up a meeting with Christina.
Okay,
are you still on?
I think Sunny's in a different area.
Yeah, so she's from a different area.
Are you in
I'm from Portland. I'm from Portland area.
Oh,
I'm not from Portland, but I'm in the Portland area.
You can set up a meeting with Dr. Van Pelt.
Okay, I emailed Dr. Van Pelt last week before last, because that was my thought is I mean SAMHSA has a really great document that says like if you're this kind of provider, this is what you do, right?
Yeah.
So they have that beautiful document that shows you the steps you need to take in different organizations. So I linked that document to Dr. Van Pelt and sent an email over and have not gotten a response yet on that. But in the past, we have asked Portland area and been told absolutely not. We've been told, and our service unit has been told by the Portland area absolutely not.
Oh, that breaks my heart. You're also more than welcome at any time to send me an email and I will see what I can help you guys with.
Okay, can I get your email? Can you throw it in the chat?
Yes, of course.
Thank you.
That just breaks my heart. We don't want to put ourselves in a position where we can't provide care under normal circumstances outside of IHS. You have to have an organized healthcare arrangement. And that generally means for us that you have at least one staff who's co-located with our staff. Then we can provide that kind of access as needed. Yeah, so,
yes.
Oh my gosh. Yes, please send me an email. I will help you see what I can do. With an OCHA, our world opens up completely different. So yes, you can do that with the release of information.
Yeah, that is exactly what I said, but but apparently my opinion was not popular, even though that's what SAMHSA says as well. So
I will see what I can do to help you.
all right, thank you so much, Heather.
No problem.
Okay, so we have a question in the chat from Desiree. She said, I need clarification on scanning records into EHR. Is this with or without an ROI? And then she had a second part, but
In order to scan any record into our EHR, or even have a patient registered in our EHR that's a Part 2 patient, we must have release of information.
okay. And she said, also, I am in a family medical home with other providers. If a patient calls me and there's not an ROI on file looking for a referral to treatment, even if I transfer to medical, is that not disclosing information?
That can depend. So if you're if you're a Part 2 provider and you're making a disclosure for the purpose of referral to treatment, that's a Part 2 and you have to have release of information. If you're a medical provider or medical receptionist and a patient calls looking for a referral, then you can make that referral medically. And it would not count as a Part 2 disclosure.
I'm sorry. So can you hear me?
Yeah.
I have other people texting me questions too. I know, so I'm like trying to pay attention. So right now, that's the concern we're in. Often our tribal members either don't have they don't have transportation. Some may be on their way to a treatment and calling me on the way, which is like an hour and a half away from me. So, and they're looking for the referral. The treatment center doesn't want to admit them sometimes without a referral. So how does that work?
You can make that disclosure. If you're not a Part 2 program, then you can just make that disclosure under TPO under HIPAA. So HIPAA regulation
So my
allows you to make
understanding
disclosure
is,
for treatment, payment, or other healthcare operations.
okay, so I guess I'm just confused because I thought
Is your program a Part 2 program or a
I'm a
medical
substance
program?
abuse clinician.
Oh, then you need ROI.
And so that's where, I mean, and we were on the last training too, and myself and the doctor were like, okay, how is this going to work between us? Because the doctor doesn't have the 100, but they do diagnose patients with SUD that goes on their problem that goes in there as well. At least that has been the practice. And right now, oftentimes I get the crisis call. And so that's why I'm saying I was told, give it to medical. Medical can do a referral, but I'm like, even if I call medical, that's disclosing their information.
I think it might not be. If you go back to the no patient identifying information, you might be able to make a referral within the regulation. So for example, if you say, oh, you need to call medical, you're still not providing a Part 2 service. You're not saying anything about that they need a Part 2 referral. If you call a doctor, your doctor in the clinic, your MAP provider or whatever, and you say, hey, I have a patient that I would like to refer to you, and you don't discuss the particulars and allow the patient instead to do that, that would not be a disclosure.
Okay. And then on the scanning, I'm sorry, but on the scanning, so I don't get the documents. Our medical records person takes the documents directly off the scanner. So I'm thinking, and I'm not sure if they're on this training. So oftentimes they're scanning those records and ROIs, if there is one, or just the information. It could be from an ER or a treatment program directly into the EHR. So is that also supposed to stop?
Yes, it should stop. If they're getting it from an ER then or a medical provider, absolutely, they can scan away. If
Okay.
it's substance use information, they should not be scanning without verifying an ROI.
If they went to the ER for an overdose,
That's fine.
still considered
Overdose is
medical.
not part 2. Yeah, exactly.
And I'm sorry, one last question. So are we going from this moment forward? Because I'm just thinking of everyone right now that has everything scanned into patient parts right now and how everything is going. What is the goal for us to implement all of this? Because it's a lot and it involves everyone.
So from my perspective, keep in mind that I've been an auditor and I'm a paralegal. My perspective, if it was me, I would document that we've been doing this wrong and this is what we're going to do to make it right. And if you can, flag those patients if they come in, ask them to sign an ROI for those that you already have in there, but most certainly pick a date forward and document that this is what you're doing. So let's just say OCR has enforcement authority and in 2 years you get a complaint and a patient, you know, files to OCR and OCR comes back looking at you, you can say, yeah, well, here's what we did. We found this and we fixed it. This is how we fixed it. So rather than, I don't want to use the term sweeping under the rug, right? Rather than just picking a date forward to fix something, you want to document what you found and how you're going to fix it. Then you pick your date forward. That would be what I would do. I can't tell you that's what you should do, but that would be what I would do.
Okay, I'm sorry, I was on mute. I'm saying yes. And so here we have Dr. Avant, and he's supposed to be a HIPAA or privacy. That's kind of his expertise. So is that something that he would be able to like document, whether it's policy or that we change? Because currently right now, I know he asked a question. Dr. Thundercloud was here as well and suggested that we have the new releases available for everyone coming in to sign. And he wanted us, I think the suggestion was not to ask patients to sign it unless the problem arises. But I have to say, as we've had all the patients coming in and signing, and they don't have to, but it's kind of, I don't know, saved a couple of times in the past couple of weeks where I've had an emergency and a crisis, the ROI is already on file.
Right, that'd be beautiful.
So, I mean,
Yeah.
that's kind of what
I
we're
would say
doing
that would
here.
be, yeah, I would say that would be a decision between Dr. Avant and perhaps your leadership at your facility, because
Okay.
you want to make sure it's documented and that you have a policy for your due process.
Okay, thank you.
Sunny asked if the example release of information and slides would be shared, and we were intending to do that. Emily, can I just send that over to you and you're able to send that out somehow to?
Yeah, well, and we'll send it out with the recording. We'll send it to Brian and myself.
Thanks. Do we have any other questions? Give it a moment. So,
I have a question.
sure, go ahead.
Is this information recorded? We're going to get a copy of the slides and that stuff?
Yes, sir.
Okay. Okay, thank you. I'm new. I work with the Catawba Nation as a certified peer support specialist, working with our support program, peer recovery. So thanks. It'd be helpful.
Yes, sir. Any other questions? Okay, I had Heather, I kind of had one related to the release of information. If it's the TPO that you were referring to, so basically for the internal communications. And when you and I were talking before, and we talked about that this would cover, so internal communications and billing. So we kind of have this overarching release of information. But earlier you were talking about health information exchange. Can you talk about the difference when you said you need two different ROIs? What those?
Yeah. So this ROI for TPO is what we call it, would be your internal communications. ROI specific to health information exchange, i.e. this box, that's to include a patient's information in a health information exchange, which IHS is moving to. So tribes will be able to participate, etc. Right now, the plan is not to include any Part 2 anything until we have all of this, ROIs in place, etc. And then looking at bringing on Part 2 facilities. But this particular ROI would be for TPO internal communication and including the information in the EHR. HIE would be including the information in the HIE, so an outside provider, i.e. like say an IHS staff member is our record and the patient goes to the tribe for services. The tribe would be able to log into the HIE and pull information for that patient. So we can't currently do that for Part 2 without a release of information. However, in this exact situation that we were just discussing, if we already have records in our EHR without a release of information, we are not permitted to include those in our HIE. However, HIE and Part 2, there's supposed to be a mechanism where a healthcare provider can break the glass, if you will, for a medical emergency. We would not be able to allow breaking the glass unless we had an ROI for this TPO. So it's a very tricky situation for us in that Part 2 information went into our EHR at some point down the road without our staff understanding how the Part 2 regulations actually worked. So our recommendation, no matter what, if you get an ROI for TPO, just also get an ROI for HIE. It would benefit our patients ultimately down the road when we do go live with an HIE. Its purpose, obviously, is to coordinate that care, and we can't coordinate it if we don't have an ROI for it.
Got it. Okay, that makes sense. Thank you. I know at the end, when you and I talked before, Heather, you mentioned a resource. So that is at near the end of the PowerPoint.
Yes. So I actually have a couple. This one is my all-time favorite one. I have worked with the Legal Action Center for 35 plus years. They've been around that long. They are literally the gurus on 42 CFR Part 2. They have a helpline. And most states, Medicaid programs actually pay for this helpline. So you can actually call the Legal Action Center at this number. They'll ask you what state you're in, and they'll look on your list to see if your state is a participating state. And if they are, you can ask a Part 2 question to any of their attorneys. So this phone line is manned by attorneys who are the gurus in 42 CFR Part 2. So when I started out early in my career, I called them all the time. By the time, I was done working in substance use, I was doing trainings with them. But they are an amazing resource. Like I said, when I lived in Alaska, the state of Alaska Medicaid program paid for this subscription. So it could very well be worth it to call that number, find out if they cover your state, if you have questions. And then the next resource I have is called COE PHI. They're an amazing resource for Part 2. They actually partner with the Legal Action Center on that website, and they run this website with funding from SAMHSA. So I can pull it up. I don't know the exact link. I just have my little bookmark, but they're called coephi.org, and I'll just put that in the chat. But they provide a plethora of information about 42 CFR Part 2 and its connection with the HIPAA regulation, etc. They have a whole ton of resources in their resource library. They have little mini trainings, you know, quickie trainings, etc. But they have a lot. And then, of course, the Legal Action Center on their website, they have sample forms, sample court orders, response to forms, etc. They even publish an ebook, Part 2 Communications and HIPAA.
We're coming near the end of the time that we have. I see that Emily put the CE link back in. Emily, is there anything else that you need to say before we close out?
No, just to get the continuing education units in nursing or medical units, you have to complete the survey that's on that link.
Okay. And how long do people have to complete that? Do you know?
That's a good question. I don't.
I think
Not indefinitely, but I'd say probably over the next couple of weeks would be good. It's not a long survey at all. It's just gathering information and giving some quick feedback.
great. Okay. Well, we might have time for one more question if anybody has one that you want to either put in the chat or come off mute and just ask.
While we're waiting, I will just make my standard statement that if you're affiliated with a tribal entity, not IHS, and you don't know, you know, maybe you want your forms reviewed to see if they meet those 9 required elements, I am always happy to take an email, check it over, and let you know if those 9 required elements are being met, or if you should, you know, need to add anything.
Desiree put in the chat. Thank you. It appears, I think it appears we need a policy showing how we corrected this.
I agree. OCR is really big about what we call the risk assessment or corrective action plan process, right? If they find something but you can show that you identified it, you worked it, they'll generally go with that as technical assistance as opposed to assessing a fine. So it's always recommended that if you do find a deficiency, that you address it in a corrective action plan and process training going forward.
Well, you're getting some thank yous in the chat for the presentation, and we will stay on for the next minute or so. But if you don't have any questions, you can feel free to drop off now. Thank you guys for joining us today.